Good evening, friends, colleagues. Thank you very much for joining us this evening for the 2023 Alan Hope Southey Memorial Lecture. For those who don't know me, my name's Matthew Harding and I'm the Dean of the Melbourne Law School. I want to start by acknowledging country. I'd like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our law school stands. And I want to acknowledge the continuing connection with and custodianship of land over many thousands of years in this place. Let me pay my respects to their elders, past, present and emerging, and a welcome to any Aboriginal or Torres Strait Islander people who join us this evening. This Alan Hope Southey Memorial Lecture is an annual public lecture that has existed since Nancy Southey made a gift to the University of Melbourne to establish this lecture in 1958. The lecture honours her husband and a graduate of our law school, Alan Hope Southey, who died in 1929 at the age of 35. His family has continued to honour his name through their support of this lecture over many years, and I am delighted that we continue that tradition this evening. Let me pay particular a warm welcome to members of the Southey family who join us this evening. This lecture is being recorded and will be available at the Melbourne Law School website shortly. In a moment, I'll introduce our speaker, Professor Lauren Willis, and invite her to deliver the lecture. Once she has delivered the lecture, my colleague, Professor Jeannie Patterson, will then facilitate a Q&A and will offer the formal vote of thanks. Jeannie Patterson, of course, is Director of our Centre for Artificial Intelligence and Digital Ethics, which is hosted jointly by our law school and the university's Faculty of Engineering and Information Technology. So thanks for being here, Jeannie, and for rounding off the evening for us. Let me turn then to introducing our speaker and the topic of the lecture. Our speaker tonight is Professor Lauren Willis, Professor of Law and Centennial Chair in Consumer Law at LMU Loyola Law School in Los Angeles. I just met with Professor Willis before the event began, and she was telling me a little bit about that law school and the very interesting work that they do, among other things, in providing access for students who are first in family to tertiary education. That was very interesting to hear about. Professor Willis has an extensive experience working across organisations within consumer law and within the sector. Before she began as an academic, she worked in the Civil Rights Division of the US Department of Justice and spent time with the US Federal Trade Commission. She co-founded the Consumer Law Scholars Conference, an annual conference of interdisciplinary scholars whose interests align with consumer issues. And she was an advisor to the American Law Institute's Consumer Contracts Restatement Project. Since becoming an academic, Professor Willis has visited universities all over, Harvard, Cornell, the University of Pennsylvania, and elsewhere. Her lecture this evening, Deception by Design, love the title by the way, will assess and propose solutions to the law's capacity to reduce consumer deception by businesses due to an increase in the use of artificial intelligence-based algorithms. This topic was something else that Professor Willis and I discussed just briefly before the event, and my preview of what's to come left me very keen to hear more. And so can I ask you then to join with me in welcoming Professor Lauren Willis to deliver the 2023 Alan Hope Southey Memorial Lecture.
Good evening. I'd like to start by thanking Melbourne Law School and the Centre for AI and Digital Ethics, and most importantly, of course, the Southey family for making it possible for me to come all the way from California to give the lecture tonight. So I'm speaking about deception, online deception, and the way in which the design of online interfaces and marketing inevitably leads to deception, and sort of how we might deal with that. So why the digital design process produces deception, barriers in proving deception that is committed in this way, and some ideas about how we might future-proof the law of deception, and a little bit of a response to what I tend to hear back from industry. Oh my goodness, we can't possibly fix this. The algorithm made us do it. So we'll chat a little bit about that. So there are sort of three elements as to why the online environment inevitably creates deceptive interfaces. The first being the sort of micro-targeted marketing that takes place, and not just marketing. I mean, really, marketing and sales are in some ways collapsed online. It's almost like the door-to-door salesman came to your home through your computer, really, in that the metrics used to assess marketing are, of course, various clicks, and that's the same for sales, and the processes are often driven together. So big data, generative AI, you all know about this now, of course. Machine learning and experimentation in real time on actual consumers as they're interacting with an interface online, and the result being real-time micro-targeted communications. So they know where you are, they know when you are, they know whether you're like the fellow on the left here who really wants to impress his friends, or the fellow who's looking at the picture on the right who really likes women's cleavage. They know all sorts of information from what we consider metadata. So not necessarily what you say, but things like how you type, how you hold your cell phone. And of course, all of this can be used for very good purposes of ensuring that you're who you say you are when you try to do your online banking, for example, or checking for cognitive decline for medical reasons. But it is a lot of information about the individual consumer's state. They know what you plugged into your Google search and are sure to make sure that the precise same words you used show up in the first advertised paid link. And of course, generative AI can do so much more now as well in terms of actually creating material beyond text, creating things that appear to be photos and videos. The result being that you can have, thousands, in fact, there's an estimate that the Trump campaign actually had 500,000 iterations of their online marketing materials and interfaces where they were asking for people to send money. So this is an example of some videos, stills from videos that were created by this system for a particular phone. So this is actually a very old photo or picture, as you might expect, but it's very difficult to represent what's happening now in online design in a physical way on the screen. But this shows the general idea of sort of looking at all these different permutations of various combinations of things online to see then who reacts to what, and associating the data of those who have clicked or not clicked with what they were shown. But really, it looks kind of like this now, iterated over and over and over and over again, incredibly fast. And industry calls this real-time personalization. I think it's more accurate to say that it's profit optimization, because sometimes what would be personally actually you would want is not going to produce the most profit, and so they don't show you what you would most want to see, actually. So the second sort of element to this is the way in which the very nature of the digital interface and how we culturally respond to it and learn to respond to it over time makes us particularly vulnerable to deception online. So we think about a digital interface as something that we control. You know, we click, we decide where to search, what to search, where to go. And it's fairly invisible to us the degree to which we are not actually making those choices, that the very nature of the technology is making many of these choices. So this is a screenshot of an interface where someone was trying to check out from purchasing a small item, and they were going to try to use their PayPal balance. And as they hit that button that says continue and stopped paying attention to the screen, where they touched turned into PayPal credit. And so now, instead of your little $10 being, or £10, I guess, to be taken from your account, it's now been, you've now purchased it through PayPal credit, and you'll owe some fees on it, particularly when you don't pay your credit bill because you don't know you have one, because you didn't know that you purchased it through PayPal credit. And PayPal was fined, millions of dollars, $15 million, I believe, in the US for this kind of thing. That's like 0.01% of their profit. It's really just the cost of doing business for them. So here's an example from Australia. When we interact online, we learn to skim, and even only barely skim. We tend to look at the tops of pages and not scroll down. Apparently, we spend only 8% of our time on average looking at the bottom 20% of the screen. And any other way of interacting online would just be paralyzing. My mother, for example, tries to actually read the whole thing and can't function terribly well online, right? The way in which we are effective is not to look at everything. And we learn certain habits, like we stop looking at things that we associate with ads. So banner ads, everyone ignores now. Pop-ups, people ignore. The little dancing man, which you would think would draw someone's attention. It's precisely the type of thing we quickly learn to ignore. So in this case, consumers were apparently looking there at the top and not looking further down. And at the top, this company was actually advertising a hotel room that was not the cheapest, despite its advertising claiming that it was going to help you find the cheapest room. And you might think, well, when you just look down a little, you can see there's another room that's cheaper here, that first one, but it doesn't draw the eye. And the ACCC was successful in going after Trivago for this kind of thing. So here's another case which the ACCC was not as successful. So here's a notification you get from Google, and you start reading, it's going to give me more control over how data is collected by Google, and then I just start scrolling and scrolling and scrolling, of course, until I get to the end, because I want to get through this and do whatever it is I wanted to do on Google. And the I agree button is helpfully already highlighted, so I can just hit return and get that. And many studies show that if you pre-select something, people are much more likely to select it. And notice also that if you choose more options, it's not like you can say, I agree, I disagree. You have to choose more options. And you think, oh, means I've got to go through more. And so you just agree. Here's another example in a game where you hit the green button to get the game going, and then at each stage where you keep moving along in the game, green just means go forwards, right? And so you don't notice that green this time means spend money. My neighbors across the street found out that before they woke up one Saturday, their son had managed to rack up a tremendous bill hitting the green buttons. In addition, online interfaces can be used to detect vulnerability. So intoxication is something that you can pick up from keyboarding patterns and from the ways in which you interact with your phone. Intoxication, exhaustion, cognitive decline, these kinds of things. In addition, I think actually particularly relevant for an Australian audience because I think there was quite a bit of information came out about this in Australia. There are ways in which online interfaces can actually invoke vulnerability. I believe Facebook was advertising, in fact, to its advertisers that they could tell them, what kind of things they could put into someone's feed in order to make them feel certain ways. So AI drives this system, and the digital environment facilitates deception. But why is it that then there really will end up happening? Deception will end up happening. Well, it won't always happen. It depends, of course, how the algorithm is optimized. If it's optimized for profit and deception is profitable, then through experimentation over time, that is what it will deliver. So sometimes people call this the paperclip problem, that if you train an AI system to make paper clips, it will turn the entire planet into paper clips. But basically, if we optimize the system to do something, it's going to do it without sort of any kind of human thought about boundaries, right? So if it's optimized for profit and if deception is profitable, the machine will find ways to deceive. There's also some interesting cases where AI programs have actually deceived their own designers, have engaged in deception as part of playing various games, even though the designers had not trained them to act in deceptive ways. So some really fascinating stuff there. So what should we do about this? We think, well, we've got all these laws against deception, so that should take care of it, right? But the types of evidence that we usually use in deception cases, at least in the US, and I believe to some extent here, are difficult to employ or impossible to employ in some of these cases. Business intent evidence, although intent is not required in US law, honestly, it is frequently used. The cases tend to use it because it's simply much easier, and an assumption will be made that if the business is shown to have intended to deceive, then it was successful in doing so. I believe there's been some issue here in Australia as well, that although intent is not required, perhaps for unconscionable conduct, it seems like maybe some judges are trying to bring in some of the older ideas about intent. But no, there's no intent, right? When all your intent was to optimize clicks. You weren't intending to deceive anyone. The reasonable person standard we frequently use in the US, and the idea being that the court then will look at what the consumer looked at and decide would a reasonable consumer have found this to be deceptive? And it's not just the reasonable consumer on the whole planet. We have gotten a little more sophisticated, and we think, well, a reasonable consumer among the groups to whom this was directed, this particular marketing or activity was directed. But when marketing is really designed for the individual at their least reasonable moment, right? Late at night, that's when they're going to click. When they're drunk, that's when they're going to click. You can't really use a reasonable person standard, or the only reasonable person within the group to whom this is targeted is a drunk individual at night, right? And it's very difficult to get the judge to, pretend to be a drunk individual at night and look at things. And in fact, we also, after the fact, often can't tell that that's really what happened, right? Because of course the computer, the system, doesn't say to itself, okay, these bits of data show drunk. It skips the drunk part, right? It just knows that these bits of data, the way your phone is being held or the way in which you're typing, is associated with you being more likely to click when a particular interface is presented to you that looks in a certain way, right? And so after the fact, we may not even be able to tell what it was that made the algorithm choose to show this person at this moment in time whatever interface they encountered. And I believe this also was a bit of an issue in ACCC versus Google. So the court here recognized that there's this heterogeneous group of people. The court says the skippers, skimmers, and readers. Now, honest to goodness, there's almost no readers, right? I mean, when people have measured how many people read the fine print in the US, it's like 1 out of 1,000 even click to see the fine print, and then they stay there for too few seconds to have possibly read it all, right? So even skimmers, I mean, it really depends for most people how fast they can scroll down to get to the I agree bit. But the court said that, well, if you didn't bother to look at that page 1 information, saying that Google was going to be taking your private information and using it for various commercial purposes, well, then you weren't acting reasonably in your own interests. Now, never mind that you're trained not to look at this, just in order to be a competent user of online interfaces. Perhaps even it was shown to you while you were on the tram, while your child was crying in the background, etc. And that is not something that's reflected in the reasonable person standard. So another type of proof that we use, at least in the US, and I think a bit here, are sort of more scientific methods of proving that things are deceptive, right? We're not just going to leave it up to the judge to figure out. We're going to use real social science. So one is we might use expert analyses. A facial analysis is what we usually call it when it's just sort of straight up static kind of materials, and a usability analysis if it's an interface in which things happen over time. Or we do consumer subject testing. So we take a bunch of consumers who are in the general group that might be engaging in whatever this transaction is, and we show them the actual materials that were shown to consumers in the field, and then we show another group of consumers, randomized of course, the same materials minus the deceptive elements of those. And then we see, afterwards, we ask them what they believe about the product or the transaction or what would have happened if they'd moved forwards. And if those were shown the original version are more confused than those who were shown the other version, then that will be presumed to be evidence of some kind of deception on the part of the firm. But doing these things is not actually socially scientifically accurate, the accurate way to test these things, because you're not showing the interface at the moment in time it would have been shown to this particular subject, right? You can't match up the actual population and the actual situation the person was in through lab testing. There's also just the problem of impracticability. The number of iterations out there of some of these things has caused our courts to throw cases out. So what, Federal Trade Commission? You demonstrated that 3 of the web interfaces and a couple of the print ads were deceptive, but the telecom tells us they had over 45,000 different ads that they were putting out during that time period, or different interfaces, and you did not manage to hit a statistically representative sample of them. Of course, you couldn't. It would be far too costly to analyze that many of them. My understanding actually here in that ACCC versus Google case is that the parties agreed that the one that I showed you was representative, but firms in the US now know not to agree to that. So what might we do about this? One is to start employing some logical presumptions. That if customer behavior is inconsistent with having understood the transaction, that should create a logical presumption that they were, in fact, misled, deceived. So I'm thinking of things like Wells Fargo. If you have a whole bunch of bank accounts that no one's actually used, there's got to be some question as to why all these people now have these bank accounts. Or if large numbers of customers are returning items or trying to cancel items, particularly if it's very quickly after the interaction took place, that could serve as customer behavior evidence from which it could be presumed that deception was involved in selling the service or the good. You could do customer surveys and look for sort of a confusion rate among customers that might create a presumption of deception. If you survey actual customers as opposed to people you put in the lab, those people are per se reasonable members of the group to which whatever marketing or whatever interface was directed are a part, right? So you've got high population validity and you've got ecological validity, right? They're only going to be able to tell you what they think based on when they actually saw or interacted with the website or the sales interface. Now, I say a 15% confusion rate. That tends to be what we use in deception cases in the US. If 15% of your customers are confused in those controlled trials, that tends to create a presumption of deceptive behavior on the part of the firm. It's also the same that we use in trademark law, that if you do confusion audits and 15% of the people believe that this product comes from this other firm, then that's considered to be a trademark infringement. So those are possibilities. And interestingly, there was a case that the CFPB brought against an online lender named Lending Club, the CFPB being the American Consumer Financial Protection Board. And in that case, the enforcement agency was saying that the borrowers had been misled as to whether there were fees associated with these loans, that the marketing had made people think that they weren't going to have to pay fees. And that was a plausible interpretation of if you just looked at some of the materials. So Lending Club actually hired a social scientist to go and in close to real time, start asking customers after they've engaged in the transactions, after they've taken out the loans, what did you think? Did you think you were going to pay a fee? Was this a surprise to you? Those kinds of questions, and found that actually only a very small number of people were confused about the fee, less than 5%, and were successful in having the case dismissed on that basis. So we also might modernize our unfairness doctrine in the US on the idea that if you are taking advantage of a customer's misunderstanding, confusion about a key element of the transaction, that is per se unfair. And I believe there's some discussion at the moment in Australia about whether you need an unfair conduct prohibition that might mirror the part of our statute that allows for this. Because really, those are transactions we don't want to have take place, right? I mean, the whole point of having a market economy is so people can actually exercise their autonomy and choose transactions that will increase their welfare. And if people are not able to do that, that is also bad for competition, right? So you have a difficulty with firms competing over who can best trick people rather than who can provide the best loan or the best service. So you also might engage in what I have called performance-based regulation. The idea here is to directly require that firms produce good outcomes for their customers. The model here is our pollution emission standards. We don't tell industry what kind of technology they have to put on their smokestacks, what processes they have to use when they're producing something, which type of fuels they use, but we measure what comes out at the end of the day. And they've got to meet whatever the caps are at the end of the day. And so the goal here would be that consumers are not confused about key aspects of the transactions they engage in, or where perhaps a transaction is inevitably too complex for a consumer to understand all the key facts. Instead, we might look to some kind of consequences cap, that poor consequences for customers need to be limited. And so we would use customer confusion and consequences caps demonstrated through audits of customers or firms' records. So here's just an example of how a confusion audit might work. You want customers to know whatever the key facts are of the transaction. You would then test for understanding of things like total costs or periodic costs or both. If it's a contract, how long the duration of the contract is, any limitations on the benefits that are provided. That's a frequent trick these days. Of course, whether they've engaged in a transaction at all is another thing that probably has to be tested, unfortunately, in many circumstances these days. So random sample testing is fine. You'd want to try to test as close to the time of transaction as possible, and so regulators would need to actually work with firms, or third-party experts would need to work with firms to get access to customers. So third-party auditors paid for by firms the same way you would hire an expert in a trademark case. And sanctions. You might require the firm to honor whatever terms the majority of the customers thought they were getting. You might even set it at more like a 15% confusion rate, and whatever the key facts are that generally favor customers. If at least 15% of customers are expecting that, then that's what they get. Perhaps people didn't think that their data would be collected because of the way in which it was explained, just didn't make sense, it was confusing people. Or they didn't see it because it was scrolling away. Well, then you might require the firm to get rid of that data, right? And fines also might be important, depending on what you need to do to change the firm's conduct and deter future conduct that's similar. So we actually did this in the US in one case in the pre-digital age, when a firm was selling a drink with advertising that made it look like the drink was made of fruit juice. So the ads had like fruit pouring into the can, when the can actually was basically sugar water, colored sugar water with a teeny bit of fruit juice. And as part of the remedial order in that case, the firm was required to demonstrate that it had, in fact, managed to inform customers that this was not fruit juice. And this was long enough ago, it was in the 1970s actually, and it was a popular enough product that you really could quite easily, without knowing who your customers were, just survey people, and so many people actually bought the product at the time that you would hit a good number from just random sample testing of Americans at the time. And it took the firm a number of years before it was able to actually get people to understand that this wasn't fruit juice. Now, the Achilles heel of the consent order was that there was basically hardly any consequence for not meeting the cap. What actually ended up happening, and the only consequence was that they had to have this sort of big disclosure on the juice saying it wasn't juice, or on the drink saying it wasn't juice. And it actually took them 10 years before they could get 2/3 of customers to understand that it wasn't mostly fruit juice. But we should have had some fines put in there to move things along, right? So consequences, audits, it probably depends, of course, what the outcome of interest is, but you could do this through surveying customers or perhaps just through looking at files. Again, third-party auditors would seem to be appropriate. Sanctions here might be, again, fines, or that the firm would have to remove whatever that poor consequence was that people were not expecting. So in the US, the Obama administration had developed some rules for payday loans that would have required, for a particular class of payday loans, for the lender, if over 5% of its portfolio were unable to pay off the loan in full when due without flipping into another loan. So people really were using them for emergency purposes, which of course is the legitimate purpose of a payday loan. Then they would be fined. But if more than 5% were unable to do so, then over the look-back period, I believe it was 6 months, the firm would have to refund all fees to all customers in that portfolio. Of course, the Trump administration made sure that that never took effect, and Congress. So here in Australia, and also in the UK, there are some interesting laws developed in the financial services area that have the potential to do these kinds of consequences audits. So in Australia, you now have the design and distribution obligations. Firms are required to design their products to meet the objectives, financial situation, and needs of their customers for financial products, and required also to have distribution systems that will get that product to the right market. And over time, if they do not, if there appear to be a significant number of customers that are outside of the target market, that are the ones that are ending up with this, or if the product is not meeting people's objectives, financial situation, appropriate for their financial situation and meeting their needs, then the firm is required to redesign the product or redesign the way it's distributed to fix the problem. In the UK, the consumer duty, which only just became effective in July, will do the same thing in a slightly broader manner, but much of the language of their regulation just cut and paste from your regulation, which is really quite groundbreaking. So this is something that is to be very exciting. I'm hoping that it is used vigorously by the regulator. So what else might we do? Well, another possibility is to start thinking about an internet commerce building code. So signage for the information superhighway, right? There are just lots of technical standards that are used online, and they're industry developed, and they tend to work reasonably well. Sometimes there's a little litigation about them, but the idea here is we need some of those standards to govern the interaction between consumers and firms online. So examples might be things like a universal cancel button. Instead of having to go through the Amazon Odyssey or Iliad, I forget which one they call it, to manage to cancel your Amazon Prime, there would be a standardized mechanism to do this. And so every service that you could sign up for, there would be also online a standardized cancel button. Now, obviously, it's not going to hit everyone. There's people who don't function online, et cetera, et cetera. We might work out various telephone ways of doing that. But given that much of the deception then happens online, this would be something to help us deal with that. Standardized toggles. I often cannot figure out whether if I move it to the right, they're going to stop collecting my data, or if I move it to the left, they're going to stop collecting my data, because everybody does it differently. It's completely unclear. This is something that should be standardized, just so we can all navigate the world. Global privacy control, this is something that's now started in the US and it's recognized legally in California, no place else quite yet, where you can install a control on your computer that will automatically send a signal back. In addition to sending information about your typing patterns and whatnot, a signal is sent back saying that you do not agree to having any of your data sold or shared. That's as far as it goes at the moment. But it works. I mean, I've been online and had like a little pop-up come up saying, we detected the global privacy control on your computer, and so we're not collecting your data, that kind of thing. Standardized checkout pages. Now, this is obviously going to be a little more challenging, but often in the checkout process, there are these little sort of things that happen that confuse people. They don't realize they've signed up for a recurring subscription. Or what happened to me once is I had left like a shopping cart open for a while, you know, as I worked on other things. It was one of those many open tabs. And when I went back to it, there was another little product in my basket that I hadn't put there. If I had not been doing this research, I would have assumed it was me, that I must have hit something, a button, you know, like when I wasn't paying attention, I hit the wrong button and it just added this thing, and I would have gotten rid of it, it'd be fine. But if I hadn't noticed it and I'd gotten it in the mail, I probably wouldn't have returned it because it wouldn't have been worth it to return the $12.99 thing, going down to the post office, packaging it up, probably paying half that just to send it back, right? Very lucrative. So setting up some standardized checkout pages is something also that we might consider doing to help people navigate the online world. However, I think you still need to do confusion audits to be sure that any of this kind of thing is not being circumvented by firms. Because it is surprising the degree to which various things that people have tried to do with online disclosures, for example, or mandatory defaults are easily circumvented by firms. So what happens when the firm says, oh, the algorithm made us do it, we can't possibly stop any of this. It'll end innovation, it will end, in the US, it'll end American companies being able to compete in the world, et cetera, et cetera. So one thing is that you can hard code to eliminate known dark patterns, right? So there are quite a few standard tricks that get done online. We call them dark patterns. You could hard code to get rid of those, not allow the AI system to change those elements. You could remove some complexity in your products or in the design of your pricing because simpler is much more likely to be understood. And so you're likely to have much less confusion. You could, even if the government doesn't manage to put together some kind of standardized pieces of interfaces, industry could get together and do that. You could actually program detection of various signs that there might be a problem with the transaction. So you could detect intoxication intentionally so as to then put a speed bump in. For example, you might require a warming up period, not a cooling off period, because once people buy it, they're committed, but a warming up period where the person would need to click again 6 hours later, 12 hours later, before they could complete the transaction. And you could just audit your customers for confusion and reverse engineer what happened and then try to put in guardrails that way. So that's what I have to say. If people have questions and want to talk about it, I think Jeannie's has offered to help.
Absolutely. Okay, thank you everybody for coming along, and thank you, Lauren, for a terrifying and thought-provoking talk. I think that often when we hear about issues that arise on the internet or with algorithms, or if we think about manipulation of consumers by design, the response is there's a lot of rules, ex-ante rules, upfront rules, don't do this, don't do that, do this, don't do this. And what I think is so delightful and important about your work is that your focus on performance-based regulation gives us real impactful measures to perhaps reduce the harm to consumers through deceptive designs and algorithmic manipulation. So thank you for sharing just a snippet with us today. And I do recommend that people who are interested in the work go and read Lauren's work. There's lots more in there. But now we have about 10 minutes for questions, so I won't hog the questions, but I will throw it to the audience. If you have a question, put up your hand. And we have roving mics, and you do need to use the mics because this lecture is being recorded, and if you don't use the mic, the people listening to the recording won't hear your wonderful and profound question. So over to the floor. Do we have questions, comments, or so on?
Thank you so much for that thought-provoking presentation. Are there cohorts or particular characteristics that are disproportionately represented among those who are deceived online?
Yes. So along a number of different respects, obviously. We do know, for example, as you get older, it's harder and harder to see the color blue. It's less likely that you'll see the edges of the screen. There's a bunch of things we know about different people and their physical abilities that affect what they're able to perceive. Obviously, we also know that people pay different amounts of attention to what's going on. Like some people think they've just clicked the continue button and then pay no attention and so don't see the PayPal thing come up. I would see it, but many people would not. But maybe I wouldn't see it all the time. So partly there is this element of some people for various reasons are more vulnerable, but there's also the issue that we're all vulnerable at the right moment in time, right? And another problematic issue is, at least in the US, there is pretty strong demographic information that you can use to figure out who is and is not likely to complain. And so if you then associate that with various data points you have about your customers interacting online, you know not to send me, a big old complainer, your deceptive interface and send it to someone who is an immigrant, African American, I mean, all of the typical things, unfortunately, because they're much less likely to complain. At the same time, all of us, like I said, I would have blamed myself if I hadn't been doing this research, right? Because we think we're controlling it. None of us are immune because of the way in which we're acting, right? But there are a few tricks. There's also evidence that dark patterns are more likely, even fairly soft dark patterns are more likely to manipulate in the US, low-income people and people of color. So various testing has been done, like who's more or less likely to hit the, agree to whatever's been highlighted versus, go on the odyssey that the other button's going to take you. And there is a disproportionate effect.
Yeah, thank you for that. I think the insight that we've been normalised or trained to click on, combined with the many people won't complain, is such an important insight to understanding how online manipulation happens, because of course the default often is, well, consumers chose or consumers didn't have to do it. But that's sort of those two important insights from behavioural psychology are really profound to that comment, I think. Do we have another question?
I might follow up just on what you just said. It
was kind of a question, wasn't it?
Yeah, sorry, just one moment. Is because of the personalized, individualized nature, though, of what you're interacting with online, it's also more difficult to know what's happened and that you've been deceived. If everybody's looking at the same ad, you might chat with someone about it, right? But if you're all seeing different things, then you're less likely to sort of figure out even what's going on and to realize that you need to complain.
Which is important, before we go to Christine's question, because people often analogise online transactions to a supermarket. But in a supermarket, you can see the whole shelf. Online, you only see what your personalised offering.
Yeah.
So.
Yeah, that actually goes to my question, because I think you were... I loved all your ideas, but I feel like some of them would be... I'm wondering who they're directed at, like which business in the whole ecosystem of what's online, and to pick up on what Jeannie was just saying. So obviously for a lot of us, it's through platforms or the big tech companies that we actually ever get to a retailer. So how would you think about what the responsibilities of Facebook or Meta or Google or Amazon are to gatekeep, perhaps, the design of and the tricks used by the retailers that might be advertising on those sites, or who they might be directing us towards, and there's kind of meta dark patterns, excuse the pun, at the platform level, and then more minor or more everyday dark patterns at the business who's actually trying to sell you something or sign you up to something. Anyway, wondering how you think about that.
Very good question. It's interesting, Google actually advertises it itself as being able to put the power of AI in the hands of every small business. A lot of this is not sort of technical expertise anybody has in-house. It's that Facebook will, as one sort of marketer of scams has been quoted as saying, Facebook finds the suckers for me, right? Because I put the product out there and the initial design of something, and then Facebook redesigns it and redirects it over time. So at first, of course, I don't get very many clicks as the experimentation period goes on. But then after a while, it gets, my particular, I mean, this was diet pills or something, ridiculous, gets targeted at the suckers. The same sort of iterative process happens with YouTube. So like the slide I showed you with all the different YouTube ads. So we're just slight variations, right? A lot of the Trump advertising was on various social media sites. And obviously there's no human making 500,000 different materials that are being sent to people. Obviously this is all automated. But the campaign isn't doing it itself. It's using platforms to do it. And so yes, this is very much something that has to be the responsibility of platforms. And we have to approach everything from a risk-based kind of perspective, of course, and really go after the most dangerous things. I specialize particularly in financial products or other complex products. Those are the ones that are easiest to deceive people about because they are confusing. But my husband goes after Amazon for when they sell stuff online that's really poison that people put in their bodies. That's pretty basic, but if no one tells you this is poison, don't put it in your body, you might buy it.
And so we could go on and on. I think that point about the dangerous products online opens another question about, I think, design interfaces. I'd recommend, Christine just has an article out at the moment actually about the platform advertising of, in this case, illegal conduct by casinos. So I'd recommend, we can perhaps post some of this online later, but it's a really worthwhile piece to read precisely on this topic. And so we've got a question from Andrew and then Shanni up the back. So Andrew first.
Thanks very much. Lauren, you mentioned, I think, that you were excited by the adoption of the consumer duty in the UK. And I understand that incorporates a principle that firms should achieve good outcomes for customers. And there's always been a little bit of scepticism about outcomes-based regulation. How do you design it? How do you regulate? How do you enforce? How do you achieve compliance? What is it, in your view, makes for good outcomes-based regulation? How do we get it right? And how do we achieve better outcomes, if you like, with that style of regulation? Thanks.
Yeah, so every situation is unto itself, obviously. I have advised them to go after sort of low-hanging fruit first. And when, for example, a firm is offering two products, one of which is strictly dominated by the other, well, then they shouldn't be selling the bad products, right? There's no reason to. It's obviously not good for consumer outcomes, so that's straight up. In the US, payday loans, and I think that the Obama administration's regulation would have been really a game changer in payday space. So payday loans are particularly problematic for a particularly vulnerable segment of people, and you can track whether people are flipping or not with these databases that are already being kept in many states, but usually at the state level, so we need to do something at the federal level. So it's got to be something that you really can measure. Sometimes that's quite difficult, but I think customer confusion audits is something that's been underexplored. And certainly if you're trying to meet customers' financial objectives, financial situation needs, their objectives, that's going to be what they subjectively wanted, right? And so if they're confused, it wasn't meeting their objectives. So without a specific context, I can't tell you sort of which thing. One thing we do in the US is for pharmaceutical products, when they move from having to be, your doctor has to prescribe it, to being available just to pick up off the shelf yourself. So we call those over-the-counter drugs. The manufacturers are required to first do a small trial run where they put it in a few stores, and then they track people who self-select and ask them questions about, do you have, and then all the things that are contraindicated for the drug, to see whether they were able to understand the packaging telling them that it was contraindicated, and ask them about dosing, and to figure out whether they understand the dosing directions. And only if people understand those things will then the drug be distributed more broadly. Of course, the problem is they only do it before those advertisements on TV with people running through the field of flowers feeling just thrilled with whatever they just took happen. And so I think that they should actually periodically continue to do those.
Thanks. And I'll just, since I'm a walking sort of recommender system, I will just point to Ian Ramsey and colleagues' fabulous work on in fact, dangerous financial products with CPRC, in fact, and Lucy, which is also worth a read, I think, in this field, talking about some of that manipulation. Another fabulous author on dark patterns.
Thank you, and thank you so much, Lauren, for your very insightful presentation. I had a question. I think you rightly pointed out Australia is at the precipice of hopefully getting an unfair trading prohibition and dark patterns potentially being hard-coded in there. But traditionally, enforcement, especially here in Australia, it relies on consumer complaints, it relies on consumer advocates complaining. So it's a reactive-based enforcement. I was really interested to hear from you what proactive enforcement could look like in this space, and what would a regulator need to do or need to change in order to be able to do this more proactively, because the complaints probably aren't going to come the way they come for other products and services.
Yeah, so I wouldn't overlook complaints. That's something, and following up on them is actually quite valuable. Of course, sometimes the complainers are the crazy people, and that's always a bit of an issue. But then the other thing that some computer scientists were sort of starting to do, and I think they never managed to get the funding to do it in the US, was to start setting up basically bots to pretend to be consumers interacting online. And then actually seeing, and they were concerned about discrimination and, various information that we don't even realize is being used to give different offers to different people or exclude people from various things when you search. So that's sort of one testing way to do it. And you might think of it similarly to the way we do sort of cybersecurity kinds of testing. The other thing is to make better use of whistleblowing and make sure that the law is very supportive of whistleblowers. Now, sometimes I honestly think that people inside the firms don't know, right? So Google had a situation where people who put up advertisements for selling people's criminal history, I don't know if you have this here, the company selling the sort of criminal history service, at first Google was, just randomly showing them to people, I suppose, as you did searches. But as people started searching for, people would search for a name, right? And this could be employers, this could be potential dates, I don't know who it is exactly. And so it would put in a name and then put in criminal history in the search bar. Google learned over time, the system learned over time, to send specifically the advertisements for criminal history to people who put in African American associated names. So even if you didn't write criminal history, say you just wrote the name, and the name is something that in the US is statistically likely to be an African American name, it was much more likely that the ads that would come up were ads selling you the criminal history. And I don't think anyone at Google realized this at first, right? I mean, I don't think it was intentional.
We have, we're almost at an end, so we'll have one question here, and then we might have one, perhaps we could have, if we can have perhaps a question, reasonable response.
Oh, sorry.
Another question, and then we'll be finished.
Yes, right.
We don't need a long, I've been told to keep to time, but so I'm going to just say, everybody be concise at this point. And we won't give you a long farewell.
Sorry.
We'll just quick clap. No, we'd rather hear you than...
So my question's about harm and the measurement of it. So obviously when it's a financial harm, I think you indicated, so about adding something to your, your basket that you didn't want to pay for, or signing up to your PayPal loan. The court is sort of used to dealing with such harms. It's quite obvious that there was a financial loss there. When it comes to loss of privacy, it seems a lot less tangible, harder to quantify and even articulate. So interested in your thoughts on how we should think about this, how we should measure it, and because it seems so critical to courts.
Yeah, so I think unless we have some consensus in society about what we want to do with personal information, we've got to rely on things like confusion audits. I mean, I do hope that as consumers, through confusion audits, as firms through confusion audits are forced to educate people more about data privacy, that citizens will then come to have stronger opinions about what should and shouldn't happen, and that would facilitate some hard legislative choices that are not being made now. But I can't tell you yet. I know some of my own personal ones, but I don't think as a society we know yet what people really want. And the last question of the evening?
An excellent presentation, thank you. I'm very interested in the role of regulation and regulators in dealing with the issues you've raised. And some of the thoughts that occurred to me was the profound erosion of free will as citizens in our community. One of the objectives of good regulation is to encourage confident participation of consumers in the economy. So we can prosecute, we can investigate. My question is, to what extent does, in educating consumers, what behavioural, what's been the success or efficacy of efforts to help people help themselves, I think is my question. We spend a lot of time worrying about financial literacy, and I know some regulators, including the one I work for, puts a lot of effort into trying to educate, but I often wonder to what extent it has any impact. So that's my question.
Yeah, well, you've run into the world's leading critic of financial literacy education. That's a bunch of work I did earlier on in my career, and makes me an interesting but somewhat unpopular dinner table companion sometimes. But the problem is that we teach people at a moment in time, and the world changes. I mean, I've spoken to financial journalists who didn't realize that some part of US law had changed such that what they thought about something going on financially, and I can think of one example had to do with people's credit reports. She thought that if you pulled your credit report, that was a dig on the report. We got rid of that in law, but she hadn't realized it. She worked for the Wall Street Journal. So, the idea that we're going to be able to keep everyone up to date as these things move is completely unrealistic. And the truth is, too, by requiring firms to meet certain outcomes, you can harness their creativity in doing various things that will inform people, right? So the little box that shows up, I mean, I used to pay attention when the box came up on the screen, right? But I have found recently that I just click it closed without looking. I, in fact, almost lost my entire document once because my license for Word was somehow defective and my whole program was going to die. But I clicked it close several times before I bothered to look, and it had morphed to become like a bright flashing kind of thing, so it was a little unusual and finally drew my attention. But over time, the only ones who can keep up with this are industry. I don't think that consumer education about these kinds of things to help people navigate the world, other than things like if we put in certain cancel buttons, et cetera, how to use those, how to interact with those. So it's pretty static, what they're learning. It's going to stay the same in the world for a while.
Thank you. We need to draw this to a close now. So thank you on behalf of Melbourne Law School's Centre for AI and Digital Ethics for coming to visit us, yes. Lauren. I think we've all benefited from your insights and your expertise. If everybody would join me in the usual way in thanking Lauren for her.
Thank you. Thank you very much.
And of course, I'm so sorry, I forgot to mention our sponsors, the Southey family. Thank you so much for making this possible. We really appreciate that we've been able to bring together such a diverse audience.